Okay.
Lucky to.
You won. It's clearly I'm discombobulated today.
I'll continue.
Did you see Mike Baxter voted back in his chair?
I saw that.
That's a really good sign.
You have a lot of confidence in you.
Yeah, actually, I am probably that have the best attendance record, I'm just saying. But not today, obviously.
I would
Yeah.
you guys go over there.
Yeah.
Like, do it all.
All right, thank you. All right, at 5:43 PM, we call this meeting back to order. Can we have a roll call, please?
Danielle Chenoweth,
Present.
Jennifer Locke,
Present.
Kyle Patterson.
Here.
All right, at Chair Chenoweth's request, I'll continue chairing this and we'll move along. Policy review for administrative hearings.
Hi, my name is Andrew Muller from Champaign-Urbana State Attorney's Office. I'm an assistant state's attorney with the Civil Division. I've been consulted on this case regarding Sui Brothers and the policy aspects of administrative hearings, the appeals section of the ordinances. At this point, the Champaign-Urbana Public Health District Board does not have rules or policies regarding these hearings. As a result, we've modeled proposed rules and policies based on the electoral board's similar process for hearing and corrections. You should have a document with 12 proposed rules. I will also make some recommendations regarding the agenda for special hearings. For special hearings held at a request for appeal based on the determination made at the administrative hearing by CUPHD, where the appellant does not believe the CUPHD has made the appropriate ruling. That special hearing is proceed ideally or based on the electoral board's template with a call to order, performing a roll call, any representation, if any, those would be lawyers announcing that they're representing parties, a review of the rules that would be in the same document, and then the parties would then put on their section of the hearing. Based on the rules proposed, number one, appearance by appellant or by the health authority at the special hearing on the appeals may be in person or by counsel. Two, on the set day for the special hearing of appeals, both the appellant and the appellant and the health authority will be required to state whether or not they are ready for a hearing on their case. There is a type of candidate. Number three, the board will grant no continuances or resetting of hearings on appeals except for good cause shown. The board may reschedule the proceeding in a case to extend beyond the initial day set for hearing if testimony is going along and so forth. Four, if the appellant fails to appear for the hearing, the board may, in its sole discretion, default the objector and dismiss the appeal. The board has sole discretion to grant or deny a motion to withdraw an appeal. Five, the health permit records of the jurisdiction or jurisdictions involved shall be contained in such records as considered as evidence with respect to all appeals to which the material contained in such records is relevant. Relevant issues include, but are not limited to, whether the appellant has a history of permit suspension and revocation, consumer complaints, inspection reports for the appellant's business, and the administrative hearing records. I will note that the history of permit suspension is repeatedly the basis for permit suspension or other violations, so it's an essential component of record.
Excuse me, what was the first part of your sentence?
The history of prior violations
Yes, okay,
in your
got it.
ordinances, second, third, fourth, fifth violation of a core violation. Those are considered in your ordinances as essential components of some of these violations. The board, six, the board will consider such other evidence as may be submitted, including but not limited to other documentary evidence, affidavits, and oral testimony. In view of the fact that the board must hear and pass upon objections within a limited time, extended examination and cross-examination of witnesses will not be permitted. However, each party shall be given at least one opportunity to cross-examine each of the adverse parties' witnesses. The board will not be bound by the rules of procedure or rules of evidence which apply in courts of law, but it may take guidance from such rules. So, and the key part, if the parties bring witnesses or testify. Each party will have the opportunity to cross-examine or ask their own questions of that witness. If the board wishes to grant additional cross or direct, that is something that the board will have to address at that particular hearing. Number 7, the Public Health District Board will only consider appeals and specifications of such appeals as set forth in the objector's petition, the written objections, and the written specifications of such objections to the original petitions as set forth in the objector's petition. No answer or response to the objector's petition need be filed. The board will conduct and preside over all hearings and take necessary action to avoid delay, maintain order, ensure compliance with all notice requirements, and ensure the development of a clear and complete record. The board shall have all powers necessary to conduct a fair and impartial hearing, including but not limited to the administer oaths and affirmations, regulate the course of hearings, set the time and place for continued hearings, set times for filing of documents, and put upon good cause shown, examine the witnesses and direct the witnesses to testify, limit the number of times any witness may testify, limit repetitive testimony, set reasonable limits to the amount of time that each witness may testify, provide for the taking of testimony by deposition if necessary, and in the general conduct of proceedings according to the recognized principles of administrative law and the provision of these rules. Rules upon offers of proof or receive relevant evidence, direct parties to appear and confer for the settlement or simplification of issues, and otherwise conduct case management conferences, dispose of procedural requests or similar matters, require the parties to prepare written briefs and propose findings of fact and conclusions of law, consider and rule upon all motions presented in the course of the proceedings, issue subpoenas, rule upon objections to subpoenas and discovery orders, and enter orders of protection as may be deemed necessary to protect against any unwarranted intrusion upon the privacy of any person affected by discovery of the proceedings. Consider such evidence as may be submitted, including but not limited to documentary evidence, affidavits, oral testimony. Enter any order that further carries out these purposes of these rules. Prepare a record of its proceedings. 8. All arguments of counsel and evidence must be confined to the points raised by the appeal and specifications of CUPHD inspection and determination. All parties shall be limited to 15 minutes each for the presentation of their case unless the board extends the period of presentation. I will note for the review of rules, I would recommend that the board would ask if either party needs more than 15 scheduled minutes. If they request additional minutes, then rule upon their request based on the facts that they present or the basis of the request. 9, if an appeal of the health authority's determination or sufficient part thereof is granted, the permit revocation or suspension will be held to be invalid. The board will state its findings in a decision in writing, noting the basis on which it is granted the appeal. 10, if the appeal of the health authority's determination is denied, the permit revocation or suspension will be held to be valid, and the board will state its findings in a written decision. In the event the board is sitting with only 2 members, and the 2 members do not agree as to the validity of any appeal, the appeal shall not be granted. 11, after the board convenes on a date and time set, it will be in session continuously until all appeals have been considered and disposed of, and if necessary, in sole discretion of the board, its session will be extended or recessed from time to time. Number 12 has to do with voting to amend the rules. In this case, as you do not have formal rules, you will be bound to, in the agenda when we're dealing with this special hearing, we present the rules. A copy of the rules are provided to both parties, CUPHD and to the appellant. If any party has any objections to those rules, the board should raise that as an initial issue after presenting those rules in the hearing. If there are no objections, the parties are agreeing to be bound by those rules. If the parties have an objection, the board should rule on that objection and decide whether or not to be bound by these rules. After this hearing, this board can adopt these rules for future hearings, and they will be bound for any future hearings will be initially bound by these rules. Anything else?
Maybe the different roles and what you envision. Who's going to be directing and asking each person to testify and sort of being organizing and saying, okay, who's first, who speaks next, that sort of thing. there's someone who will swear each witness in to tell the truth, the whole truth, and nothing but the truth, sort of in a parliamentarian. And your role with, you're here on behalf of the county, what you think would be better for you to do, for me to do, and then Julie's role and Sarah Michaels and the others versus the board.
So the board, under these rules, would be responsible for swearing in, taking both the individuals testifying. I would anticipate Mr. Allison as the appealing party to speak first. He would be sworn in, and the witnesses that he has would be taken first, and then CUPHD, Julie and her staff would go second and present their case. Any additional witnesses that they have, I know that CUPHD is considering some outside witnesses, ideally would be disclosed beforehand so that the board is aware of any additional time that they may require for testimony from those witnesses. My capacity would be limited in this hearing, that's how I'm envisioning this, as I am employee of the county. I'm involved in this case primarily to litigate temporary restraining order and preliminary injunction. Ruth, I would anticipate you would be the board's attorney for this, and you will not be directing CUPHD testimony. CUPHD, if you require an additional counsel for this hearing process, I want to discuss that with you beforehand, because again, I am somewhat limited in this process, and I am handling other legal matter in circuit court.
I don't think that we will, because, I mean, I've already heard the testimony, and then I have the division's testimony, and it's all written out, and it's all, you know, in paper. You guys all have it now too, so I don't think I would need, you think I would need somebody?
I don't think
Like,
so.
I'm not even gonna be probably speaking, because I've already been the
Well-
judge, if you will, for the last one, so.
Your department has already provided a packet of materials for the board to review. The board can review that in advance, not making any determination based on that material, considering that material. CUPHD staff can refer to that material as it's already in the record, and then direct the board to the provisions of the ordinances that apply and standards that are currently being operated under. And I mean,
If these documents have not, the ones that were forwarded to us in that packet have not been provided to Mr. Allison yet, I think.
They haven't.
They haven't,
So
okay.
yesterday, all of the stuff, all of that packet that you guys have now, except for the one I got today,
Mhm.
and then I got paranoid and was afraid that I might have forgot to send the thing, so we might have gotten 2 copies of one of the things, but he has everything, or he will have everything.
When you say today, you're
Yeah.
on to the rules.
Yeah,
Okay,
because
because I
I
don't
sent the
remember the
rules
rules,
today.
but I remember everything. These other items.
And so we'll just want to, I think, and maybe as my role, we'll say these were documents, these are already part of the record and have been admitted as the record. In a hearing, normally you would ask each side if they want to make an opening statement, and then they can present their evidence, and then a closing argument, you recommend that as well? Or not
No.
necessarily so far?
I believe that wouldn't be a problem. Again, we are intending to bind parties, both CUPHD and Mr. Allison, in 15 minutes. The manner in which they use their time, they primarily want to rely on an opening statement rather than closing. I don't think there's ever a problem with that. That is the typical hearing process. So I think that's probably the cleanest format to present to Mr. Allison. But if he chooses not to provide a closing, I don't think there's an issue. But typically, again, it goes through an opening statement where the person presents their baseline argument and then their actual evidence and testimony. Mr. Allison, based on the video I reviewed from the administrative hearing, was most likely have an extended opening where he lays out most of his evidence.
And we'll remind the board in its decision-making that neither opening statements nor closing arguments are evidence, and they're only to consider the evidence. So opening statements are to give the decision makers an idea of what the evidence will show, but not necessarily, but unless it does show it, they can't take it as evidence.
Does he present evidence in writing?
I I don't believe he's
them.
provided any additional documents to the board at this point. If he chooses to provide them on the day of hearing, the board can also choose to take some additional time to review those during the meeting. Or else to review those and so on. That's in here. What I would say is if Mr. Allison chooses to put on all of his evidence in an extended opening as he's a pro se litigant, and that this is not entirely bound by the rules of evidence in these hearings, that there, as long as he's agreeing to and complying with the 15-minute requirement, that he can proceed with that. I don't see the board having an objection to that unless he begins to exceed 15 minutes. Now, for CUPHD, if they choose to divide their time to an opening statement and then testimony, or simply enter testimony and give a closing statement, I think CUPHD just needs to present how they want to do their format if they're choosing to break their time out that way before they begin their testimony.
So he would say, you know, his piece, and then how I'm picturing it, and tell me if we need to change this, he will say what he did kind of in the hearing, but instead of me just listening and not saying anything, or having anybody say anything for the most part, then Sarah would get up with the evidence packet and, you know, refute or whatever each part, and you guys could ask questions, correct? Can they ask questions?
Yes.
Okay.
Yeah, just process what is, so that I understand, you know, there are multiple warnings, he was shut down, you spoke to, as an internal hearing, and
Maybe not
Those
put it
are,
to talk
that's
about.
getting into
Oh,
the facts
that's
of the
different.
case,
Okay.
that's something you're gonna wanna consider at the hearing itself, and I can't discuss that now, because that's.
I just want to understand what comes out of it. I would like a big picture understanding of, and the big picture understanding is like, there is a case in court.
It's an
and
absolutely
there-
separate case.
That
And
case.
there's this hearing, and then can he appeal our decision process-wise?
If
Can he
he
appeal the
disagrees with your determination, what
Okay.
he's going to do in essence is appeal his closure to the circuit court in the
Okay.
temporary restraining order case,
Okay.
and say that you lacked authority to do what you did,
Okay.
and then that will proceed in a hearing in the circuit court. There is a separate lawsuit that currently is uncertain, is not an issue at this point,
Okay.
but does exist. That is entirely separate from either of these two matters.
I see. So typically in this situation, we would, is the process videotaped?
Well, it's an open meeting, so I don't know.
Okay, so we should
It would be-
videotape it.
My thing was videotaped,
Okay.
and I met with him.
You will be making a record of this. I would recommend acquiring a transcript if you have a court reporter in the room, or someone who can provide a transcript based on the reporting. You will also need to provide a written determination either for or against the appeal at the end of the hearing.
Okay.
Where
There
would
can
one
be a
get a
basic
court
template.
Okay.
Area-wide court reporting services can do that. So Andrew, would you suggest we contact area-wide and just ask them to be here? And, or do we contact area-wide and say, we're going to be video and audio taping this meeting. If there's an appeal, we will be required to provide are required to provide a transcript.
The transcript will also be useful for my case, so I may require a copy as well. So as
All
long
right.
as you have one available,
So,
that would be.
Julie, can you contact area-wide reporting services and ask that they bring, have a court reporter here? And that way.
And then we'll also have it videotaped, so,
I think that makes sense.
As to,
okay.
as to the written ruling, Ruth and I can come up with a basic template that you can then fill in.
For the
during
written
hearing,
determination.
And then a full formal document will be issued to parties,
And,
either for or against.
I suppose no one's asked this, and I don't know that it's included in here, but if there are any witnesses who want to or need to appear by Zoom, do we want to address that issue now?
I have not specifically included that in here, because that is something in the determination available to the board on the scene. I can say CUPHD is intending to have representatives appear remotely, that if they have that, they would submit that to the board, I can lay in advance, and then the board can decide whether or not they want to accept that. I haven't bound the board one way or another in these rules, as that may change over time. If Mr. Allison has other witnesses who wishes to appear remotely, and we granted that to CUPHD. I would recommend that the board reciprocally grant virtual appearance to Mr. Allison. Not to Mr. Allison, but to his witnesses.
And just to tell you, big picture wise, like you said, I can say that right, like we've never gotten to this part, so we've never had anything beyond because we just haven't. So afterwards, we may want to discuss moving forward how we want to do this thing because, it's something that could be dragged, it's just dragging out. And it was, I don't know, it just seems like, I'm not even sure what, what is the issue? Because.
Well, his current, I don't want to get into the substance of this,
No, but-
that's yours. Currently, he's objecting to your determination.
Right,
I don't-
And I think to his authority as well, right?
The court case, he has cited lack of authority.
Well, who
but-
would have authority if not us?
So,
But that doesn't
He-
apply in this hearing that we'll be doing next week.
he will be contesting the inspection determination and then the administrative determination from CUPHD.
Yeah.
So I don't believe he's supplied any more specifics in his appeal nor the petition for appeal, just a request for an appeal. At this point, I would just follow that. If it's with a special hearing, if he doesn't come with anything more formal, CUPHD's position would be a series of formal points on jurisdiction and authority to sanction individuals not complying with the ordinances that they enforce. So ultimately, both parties will have a chance to submit a piece, present any witnesses or additional evidence that they have. If they have additional evidence that they bring to the hearing, the board can take a recess to evaluate that evidence and ultimately take a recess before issuing a determination. We recommend that determination take place either at the hearing or shortly thereafter so that this does not drag on. Because I have the court case on the temporary restraining order preliminary injunction the following morning. So if we have a formal determination, that would be ideal.
Will we be able to deliberate amongst ourselves in closed session?
Yes, you can take I would say, be taking a recess from the hearing that your deliberations are somewhat closed in that setting for a closed session.
Go use my office.
So we can recess to your office and deliberate, so we're not voting to go into closed session?
I don't know.
It wouldn't be a meeting in the same sense that we hold meetings now, it's more adjudicative.
Yes.
And so it's not by vote, we would just.
I think you can just go into this closed session, and then make to deliberate and then go into ruling. I don't think there would be a court reporter who would be part of that closed session or audio or video tape.
Since this is an administrative hearing, I don't think you have to go to that extent. You just have to make sure that your determination is public record.
So is OMA not cover this?
It doesn't. This is going to be a public special hearing, but it's an administrative or adjudicative hearing where you're deciding facts, whereas a public meeting or public discussion of those topics is ongoing, is different. Yes.
Just as would it be similar to like a trial is open to the public can watch that, but they can't watch the jury deliberations. And we're essentially we're not a jury, but we're essentially for this hearing, the fact finder, right?
Yes.
So that's why they wouldn't have to.
It's a slightly different role,
Yeah.
still public body.
Yeah.
It's the same as when the election board hears objections, they can consider those objections, but the deliberation evidence has to be public record. So their determination is public record.
So we can't just, when we come back from whatever deliberation, we can't just say, we agree, we have to say we agree because. Or we say, nope, too bad, and because. Yes, okay.
Specificity.
Yes.
So this hearing, like, we've not done it before locally, so is it something that is created by statute?
It's created by your ordinances. Your ordinances consider the administrative hearing process that CUPHD does in response to someone disagreeing with their inspection. And if somebody disagrees with that determination, they then can appeal to the board.
But we
The phrasing of the ordinance
Yeah, and how
that
that's,
contemplates an additional level of appeal.
and we have had those in the past, it's just never gone beyond that, because, you know, we have it, and usually it's just a thing where I sit there and listen to their, play out every single thing that they, you know, wanna bring up. Listen to that, and we've had some who bring attorneys, but I think the last one, they brought somebody from corporate and an attorney, and we just listened to everything, and then they actually said, this is, oh, okay, you have the authority, and these are ordinances, so we will follow these, and that was the end of it, so.
I think Kyle's question is important because, and maybe what I'm here, like, as the chair of the board, I want to have written rules, obviously, and I want to know where our authority, like, I want to understand the ordinance. So what is the specific thing that creates the structure for this hearing,
It's in
given
the-
that these rules are new?
It's the retail food enforcement policy. I believe section 6 is the appeals section of that ordinance.
I don't have that
Um, actually,
I've got all of the packet, yep.
Is it in the pack?
It's,
It's in this.
It's in there.
and the ordinance.
Oh,
is
okay,
written
yeah,
down.
this one,
Yeah.
okay, thank
So
you.
what's new is
Mhm.
how we handle it.
I see.
How we'll handle it. So that's why we have to begin by saying, hey, these are gonna be our rules.
Mhm.
But then moving forward, Julie, I think you're right, it's a great idea for us to adopt this. Moving forward.
Or to say, I mean, there's no reason for the second appeal, because I mean, there just isn't.
It's America.
Is here
Well, I know. We have-
It's
there is-
appeals process.
Yeah, there is the appeal, we have the
Oh,
appeal,
one
but then it goes to the court,
I
basically.
haven't turned over.
So, you know, I don't really know.
This might have-
So if the administrator is enough and not having to go administrator and then here.
Yeah. And it,
No, I
and
got
they're
it.
gonna,
It's
I mean,
just
they say the
enforcement,
whole
yeah,
thing,
it's the
so I could.
enforcement.
It's 6-4 appealing decision for the health
Yeah.
authority.
Yeah.
There's
So-
no,
Yeah, yeah, go ahead.
who's talking about
So-
the ordinance and state bills, the state has nothing to do with this, they don't care, and they're just like,
They sent
So-
back to us.
yeah.
So in 6-4 appealing decisions of the health authority, subsection A, appeals, a permit holder or operator whose permit has been suspended or revoked may make a written request to the health authority for a hearing to contest the conditions of the suspension or revocation. In such cases where a permit has been suspended, a permit holder may additionally or alternatively make a written request to the health authority for reinspection. Any food establishment for which the permit has been suspended or revoked shall remain closed during those periods when an appeal and/or hearing is being sought under consideration. The permit holder may appeal the final decision of the health authority to the health district or its successor.
Okay.
So the
Yeah,
health district or its
that's where-
successor would be.
So that's where we are.
And can I
Yes.
clear up something with this? That had he have just stayed closed, we would have just been going through this process, but because he didn't close when we closed him,
You ripped down the placard.
we ripped down the placard and we went to the paper and said, I'm staying open. That's why we had to go.
So I think,
For that
yeah, at
case.
this point, this is kind of like litigating the facts that are gonna be in front of us.
Oh.
I can see Andrew's face.
Oh, okay,
doing
sorry,
it.
sorry.
Yeah.
I just meant that,
Currently,
Yeah.
it's
It's-
just the third, it's
It's the next step
the
in what our-
inspection to appeal for the administrative hearing to appeal to the health district or successor, which would be your board.
Okay.
and your part in there, your thing is the temporary restraining order because it wasn't closed.
So
Right.
currently, there is an
And-
enforcement order that would be heard subsequent to this appeal, because once the administrative process is done, then the circuit court has jurisdiction over these issues.
So I just have a question for function of it all. CUPHD should come prepared with who from their side is going to ask questions of any evidence presented if there is going to be, right?
If they wish to
If they wish to.
cross
It should be- yeah.
Mr. Allison regarding his testimony, they can do so.
Yeah.
They can choose not to cross Mr. Allison and proceed with their own evidence as they choose.
We should not rely on the
But that is
board
not
to ask
their-
questions because
The
we're.
board may
are-
also
yeah.
ask questions if they feel a point needs clarification, or they have a concern over something that was said.
But for this the board is
The board's
neutral
not-
decision making.
Right,
Yeah,
the
we're
board
not
doesn't,
advocate.
We're not
doesn't act
advocating.
as an advocate for the public health
Yes.
district.
You are separate
case.
entities for this.
Mhm.
The CUPHD, if they choose to cross Mr. Allison, that is not taking time from their 15 minutes to present their case. That is, as long as they're not going wildly over time with such questions, I don't think the board would have objection.
And the same was when he,
And then
yeah.
he will have the opportunity, if the board wants to pin down a specific amount of time for cross-examination, that's possible, but not standard part of these rules. And these are modeled after the election board process for appeals or objections to candidates in the electoral process.
Do we use Robert's Rules of Order?
You are not bound to the court process of rules of evidence. Robert's rules, I don't believe Robert's rules really contemplates hearings or hearing process. So you have a little bit of flexibility in how you choose to administer this, but you can use the rules of evidence of the court process as a template.
So
Just
just-
you are the judge for the purposes of this hearing.
So dress rehearsal, I just want to walk through this. This is very helpful. Thank you for pulling the rules from the election board and for helping us through this process, which clearly we'll need to do some cleanup afterwards in terms of putting these rules in place more permanently. So it sounds like we convene, we turn on the videotape, we make sure court reporting is here from area-wide. The chair calls the order, the chair does a roll call, or the secretary?
I think the secretary.
Secretary does a roll call, so that, okay, thank you. And then, there's a swearing in, is that
Well,
done?
First, you would call any representatives, the parties bringing an attorney, and sworn person will as their attorney.
Okay,
You then would do a review of the rules,
okay,
so the same 12-section rules focusing on I would focus primarily, by your attorney. The 15-minute section that the parties are agreeing, 15 minutes to present their cases, that
Yeah.
the parties have the opportunity to cross, and so on.
Should I-
You would then ask if either party objects to the rules as presented, and then hear any objections and rule on any objections. You would then, again, clarify that each party has 15 minutes and ask if either party requires an extension of that time for any reason. And then we hear those reasons and either grant or deny extensions of time. The
Okay.
parties, I would expect, if they're running short on time, may also make a request toward the end of their testimony for extended time. And the board can decide whether or not to grant that.
okay.
Then you would call Mr. Allison, ask if he is ready to proceed. CUPHD is also ready to proceed. And then you would ask Mr. Allison to call his first witness. or
So we haven't
that's-
sworn in yet.
Well, each
Or-
person, when they are ready to speak, okay, first we'll swear you in. And then the secretary could just say, "Do you swear to tell the truth, the whole truth, and nothing but the truth?" Raise your right hand. I do, okay, and there you go for each person.
And I again, counsel some flexibility for Mr. Allison with going directly into an opening or directly into his evidence and using those 15 minutes at the outset. You're not required to bind him to an opening for 5 minutes, testimony for 10 minutes, and then closing for 5 minutes. You could let somebody bind themselves that way, but I don't expect Mr. Allison to ask for that.
So 15 minutes with cross-examination or no?
15 minutes, and then CUPHD has the opportunity for cross-examination.
But 15 minutes, I'm sorry, includes their witnesses,
Yes.
Yes,
okay,
unless they ask for a second.
unless they have for extension, and then there's cross-examination. Does it make sense to have an opening statement from both parties so we understand the state of play, or no? I'm looking at the board. And then, like, get into the weeds, which is witnesses and cross-examination. That's how my brain works, is in a pyramid,
I think if we
so.
ask for a brief opening statement from each side,
Okay,
and then,
If you're asking a pro se litigant for an opening statement, you want to be clear about what the opening statement is, that they're just stating
That it's
their
not
position,
evidence.
and not getting into the facts until their testimony.
okay.
I mean, sort of, the opening statement is already done, that's why we're here.
Okay.
I mean, I don't know, but
or I could ask
It's
if you
just-
wish to,
it's
but
a
like,
recap.
let him know.
how, okay, how it went with, when I did it, was just, he gave all his stuff, and then I
If the
listened.
board
and-
asks for an opening statement to recap his essential position and just provide the essence of his argument without proceeding into evidence, and then provide his evidence after a brief 2 to 5 minute.
We can ask if he wishes to, he may
If he
wish to go
if he
straight into.
chooses not to,
Yeah.
then CUPHD may also give an opening statement presenting the basics of their position and then getting into the evidence, but that is up to CUPHD to determine how they want to use their 15 minutes.
Yeah, I would say that we already, unless there's a different argument, we would just, based on what he says, then we will respond to those things.
Your strategy for this hearing is separate from the board. The
Oh,
board.
it's-
is
Everything has to be
considering-
new to us.
Yeah,
Like
that's
if
true,
we-
I'm
If
talking
you
about
wanna
us.
if you want to discuss how you're going to proceed through your testimony, I can talk to you
Okay.
about that separately.
Talk
But
to-
for the
talk to
board's
Sarah.
purposes today, you're given 15 minutes to use how you will.
Okay.
You can choose to do an opening, you can choose to do a closing, but the board will be holding you to either 15 minutes or, based on your request for extension, at a different time frame.
And do the witnesses eat, like, all go, and then there's cross-examination, or is it witness cross-examination?
Witness cross-examination.
So basically, they have 15 minutes with witnesses and the 15 minutes part is with witnesses and then cross-examination.
Cross-examination is not counted against.
Right.
Okay,
So
so
we
here's,
keep a timer
here's,
going
so-
of-
Here's what I would suggest, if you picture it, I'm Mr. Allison, I'm gonna testify, start your timer, I testify for 3 minutes. Then Sarah Michaels cross-examines, you stop the timer, and Sarah says, yeah, but what about this, what about that, what about that? Allison responds. Then Allison calls his wife, and his wife testifies, you start the timer again. And
Ask you to set the timer.
does that make sense?
So the secretary, well, when we review the rules and say 15 minutes, we'll explain that the secretary is holding the timer. And when we open the appellant to speak for 15 minutes with witnesses, I'll remind that we'll be just doing his statement and the witnesses are 15. And based on this, I think it makes more sense to not do opening statements, but this is helpful. So I think,
You can also offer, I've done this with some cases, administrative cases where if someone's on a timer, you can offer them a warning.
So we can also grant a little grace to a pro se litigant if he's not represented by counsel, we
Yeah.
can offer some grace, but, within rules.
yeah, I'm not a particular hard ass. The piece that after the roll call of the secretary, you said calling the reps and attorneys, is that just basically having the attorneys named? Do you have an attorney with
They
you?
would stand up, say they're representing a given party, and then that person would be responsible for calling the witnesses.
I see, okay.
If he's
so-
representing himself, he's just saying he's representing himself, CUPHD, but he's saying they're representing themselves, et cetera.
And the attorney would then be in charge of the cross-examination of the other side's
Oh, if there's an
witnesses.
attorney, okay, they do, and so basically, it sounds like in this case, neither party will have an attorney.
Correct.
The board will have an attorney, will be there, and the staff and Mr. Allison may each be doing their own cross-examination, but we would need to allow for that. Okay, and so, review the rules, call Allison and CB, are you ready to proceed? Secretary, you swear folks in. Appellant has 15 minutes. You'll do the timing. If there's new documentation, I can call a recess to evaluate the documentation, which would probably be, we wouldn't go elsewhere, we would stay here just to take some time. We can ask for clarification at any time with the cross-examination, or would you recommend at the end?
I'm sorry, was it cross-examination?
I think she's
Yes,
asking
we asked
what
for
if the board member asks
clarification.
a question, does that count towards time?
It would not count towards time, and I would suggest that after there's cross-examination, I think the board members can chime in at any time, but it makes sense after cross-examination to
Okay.
ask. And then once the board member has finished asking the questions to the witness, then the witness is asked, do you have anything further to say based on the questions that were asked either by the board member or in cross-examination? Same to the other side as cross-examination until all have said their piece.
Okay, So basically, after we ask clarifying questions, we can say, do you have anything else you would like to say? And that's within the 15 minutes roughly.
That's correct.
Okay, and then we could offer closing statements if we would wish.
A closing argument if they want.
Okay. And we could probably set a time around that.
Right, or you could just set, you know,
Mhm.
I would expect each side would just should succinctly say, we're right, they're wrong, they haven't proven their case.
Okay, and
That's usually
then,
what that comes down to.
Yeah.
and then basically, we do not vote on a closed session. We take I basically at the end, after closing arguments, say we are taking a recess. We can go to Julie's office, no court reporter. This is not an OMA violation.
Correct.
I'm looking at both attorneys, it's not an OMA violation, okay? So we're going to Julie's office, we discuss both our determination and the reason for the determination. We probably have it written out, and then when we come out, the chair says what the determination is, it's not a vote, correct?
That's correct, because you've already voted to make that
Okay.
decision.
And then you issue your written statement.
We
So
made,
about the written statement, if we could have just a draft with like fill in the blank
Yes.
provided to us, like, you know, check up,
Right, we believe that the appellant has proved his
Yeah.
case by a preponderance of the evidence, or that the appellant has not proved his case by
And then it's just a
preponderance.
simple majority of the three of us.
That's
So if
correct.
two say yes, one
Right.
says no,
Now,
two
if
say no, one
only,
says yes.
if only two people are present, it's the appellant who has,
Yeah, he has the burden, it would have to be both,
Yeah.
yeah.
Appeal is not
Yeah, let's not
granted.
even-
right, because
Oh,
it's the
yeah.
appellant who has the burden of the proof, burden of proof.
That's enough, so.
and so you said though, we had taken a vote at some point.
In
You mean
in
in
your,
closed session?
yeah,
I
because
mean,
you have
in
to
a
determine,
recess.
I would
Yeah.
say that's more of a whole.
okay,
Yeah.
Vote,
sure.
the vote would be
Yeah, we can discuss and then we reach our
Okay.
determination based on the evidence that we
Okay.
much like a closed session, when we come out of closed session, we return the final.
Okay, so then we basically come back from recess. We do not do, we basically state our determination in open session. And it should have reasons and specifics, and then, at that point, we close. Is that
And
correct?
what it sounds like maybe is the way to do it is similar to how you vote on these things. Is there a motion by one of the board members? I move that we grant the appeal and find that the appellant has proved his case by a preponderance of the evidence. Is there a second? All in favor, say aye.
Okay, so you
Or-
do want us to
I-
vote?
That's how I'm hearing it from you, Andrew, is that right or
It's
no?
probably the cleanest option for a
Okay.
board like this.
Yeah.
So that would be,
Yeah.
the motion would either be, and so you think this like in a, when the jury does their polling, you know, we find this, so, but it's with a second, yes, or the, I move that we find that the appellant has not proved his case by a preponderance of the evidence, and therefore the appeal fails. Is there a
We
second?
did not do the appeal, yeah.
So whoever thinks that they, based on your straw poll in your meeting, is going to be successful would likely be the one making the motion.
Okay.
And can you go into the room with them in the?
Yes.
Yeah, okay. And then we'll just sit, I will just sit in the audience, correct? We'll just
Yep.
be in the audience, and
Just-
I won't be, unless I'm called upon, I'll just sit there.
Okay.
And as I
Because
said,
Sarah-
my anticipated role is sort of limited, I
Well,
would
what's
be
the
present,
in the
I'll be
audience?
present, and,
Mhm.
would be your counsel for this.
Okay, and then no vote to close, we simply are like, you know, with that, the hearing is now closed.
Right.
Okay,
Yeah, evidence is closed, and
We'll
we'll
adjourn.
adjourn for this deliberation, and then come back into the session and announce our.
okay.
And then after that, go into closed session for,
Oh, there's a
The
thing
Carl
on, a
situation.
Carl.
Oh,
it's that
It's
will take
a
long.
2-minute presentation,
Yeah.
not
Wait,
big.
yeah,
Just be
after,
clear that
sneak
you're going in
that
on
on us.
A different
on a
thing.
different topic.
Correct.
Yeah.
We'll
Maybe
have,
give
we'll
just
have two
Allison
things on the
opportunity.
agenda.
oh, okay,
Yeah, I think we would have two pieces of, essentially two pieces of paper, like you'd have in a jury verdict form, so that,
Yes.
Yeah, that would
Right.
be easiest.
and that way you got your rule.
You just had a little blank space for us to say comply,
Yeah,
so bad
and you-
transition. Yeah.
and so we do need to, with the review of the rules, is it a summary, or you basically read this to us, should we
He read
read
it.
this?
I read that to you. I would read that, just so you're
Okay,
familiar with what your rules
read
are.
the
but
rules out loud, okay?
Oh,
Well,
no, I
Oh,
don't
no.
think we need
If
to.
it's
you
provided-
can just say, these are the rules provided to both parties. Does anyone have any objections to the rules adopted by the Champaign Public Health District Board? If they have any objections, then hear those objections.
Okay.
And you clarify that pursuant to those rules, both parties have 15 minutes to present their cases.
Yeah,
Do
and
you
if
have
there are
to-
no, I'm sorry, no objections, then basically we take a vote, or we say they are adopted.
I
No.
would say, based on the lack of objections, these rules will be binding in this special hearing. And then 15 minutes.
Otherwise, you do vote on any objections, like if they wrote on.
If they have an
objection.
objection, you would vote on it.
Okay,
And if CUPHD has objections to rules, then you would also hear those.
Okay.
Either party can raise an objection.
okay, thanks, sorry, good.
No, I was gonna ask the same question.
Yeah, I'm so used to parliamentary procedure, I'm be disoriented.
Yeah,
Just saying, I know how to run a meeting. I
I
know how to
court
facilitate.
experience if you want me to.
Talk and
I was almost gonna
facilitate
suggest that.
consensus meetings of
I mean-
unruly activists and, all kinds of things. It's fine. This is
You're
clear.
a chair, but if we think it would be better for somebody who's done this sort of stuff before to run it, I think
It's a
not,
good
but-
experience. I can do
Got
it, but thank you.
Yeah.
Cool.
yeah.
All right, I mean, this is why I'm asking all the questions, so.
And just to recap, you are free to review any materials that the parties present you beforehand. You're not deliberating or making any decisions based on them. You're taking them as baseline information to inform the hearing.
So we can consider what we've received in this packet, even if like
Right.
nobody
But you
talks to us after.
Yeah, you should not be talking with any of the three of you or any employees or Mr.
About
Allison
what's in here, we should
about
just,
anything in the
but we
packet
should
or about the
review it
hearing.
beforehand.
About
Usually, you
evidence.
should not be approaching the board regarding the
Right.
content of that.
What about, the appellant? If he reaches out to
If he
us,
provides you information or documents or materials, you can consider that evidence in advance of the hearing. If he's reaching out to you with questions, statements, or I just want you to know, you can take that as documentary evidence and consider it. But you will not, don't engage with it. You just clarify the hearing is scheduled on.
Yeah,
And if
and-
if he reaches out to one of us, we just forward that conversation to
Me,
the full body here
Well,
and.
share it to the body and
And-
provide them with another copy of the notes.
Yeah, I think so, and to Julie, and I think to, so that everyone has everything.
Yeah.
That's the
Yes.
idea. So it's next Wednesday at 5 PM, correct? 16 of April at 5 PM? Okay.
And I already submitted the request for a court reporter,
Thank you.
and then I will follow up tomorrow. They have an online thing to do it.
I have not used their service before.
Yeah, they're great.
Are they quick on turnaround on that? Because I may want to
Yeah.
enter that as an exhibit.
Yeah, as long as we let them know, so when they confirm, if you can say, we'd like to have a transcript immediately or next day or that night if possible. Yeah, they can do that.
Thank you. The board has no further questions.
Thank you, Andrew. We're good?
you have to adjourn the meeting.
Jennifer, do you want to ask if there's a motion to adjourn?
There we go. Next monthly meeting is May 14th, 2025 at 5 PM. Is there a motion to adjourn?
So moved.
Is there a second, Paul?
Honestly, I don't think Robert's rules requires that, but.
Well, there we go.
Sure.
So we adjourn at 6:32 PM.
Are you trying to share one on the therapy dog on me?
No, but I thought it was so exciting, it's the most part of the meeting tonight, because that's actually pass that off.
There's going to be a therapy dog for the dental